Hello and welcome to VideoCam and AudioCam for Cam Scotland. My name is Scott Docherty and I'm here today with Lisa Parkinson. Lisa's been a practising mediator since 1978 and although it would take the length of this entire interview to list her achievements in pioneering mediation in the UK, in the interest of brevity, I'll mention only that she co-founded the UK's first mediation service. She co-founded the Family Mediators Association with founder members of the body which became Resolution. She coordinated the first training courses for the FMA and Cam Scotland, having developed the role of solicitors in mediation. Was a founder member of the European Forum for Family Mediation Training and of the World Mediation Forum. And as if all that wasn't enough, literally wrote the book on family mediation. So welcome, Lisa.
Thank you very much. Welcome. Thank you, Scott.
Good. So, in an earlier interview, I spoke with Anne Dick, who was with you on the journey of mediation in Scotland. And I wonder if you could take me through, first of all, how you were involved in the development of mediation and Cam Scotland up here.
Yeah, I think it was actually Julianne McQueen, who was then the director of the Scottish Council for One-Parent Families in Edinburgh. And Julianne had a friend in Bristol who was a social worker, psychiatric social worker, whom I knew. And so Julianne heard about our sort of pilot service in Bristol, which was the first in the UK, I'm fairly sure. And that led to Julianne deciding to organise a conference in Scotland, the first conference on family mediation in Scotland, which was in May 1981. And Julianne invited me to come up to Edinburgh and talk about our scheme in Bristol and how it was going, how it worked. And that led to a committee being set up in Edinburgh, which set up the first family mediation service in Edinburgh, which was the Lothian service, which, like our service in Bristol, was providing mediation in relation to children matters. Not all issues, but children. And then that spread across Scotland, and there was a Scottish Association of Family Conciliation Services, as it was then called, SAFCOS, which I think was set up in 1986. And by that time, I was involved in developing mediation on all issues involving lawyers as mediators, which we started in London in the mid-80s, having got the green light from the Law Society of England and Wales. And I was co-mediating with very experienced family lawyers as a pilot project, which led then to another national association, the Family Mediators Association.
Yes.
And then I think the next development was that the Law Society of Scotland, who obviously had followed what was happening south of the border, invited the Family Law Association in Scotland to run the first training for family lawyers in Scotland in family mediation. And Anne Dick was the founder chair, I think, of the Family Law Association. And she approached, I think she'd already come down actually and taken part in one of our training courses. And there was an approach from the Family Law Association to the Family Mediators Association, of which I was that time director, asking whether we would cooperate with a course up in Scotland. Okay. And the FMA, Family Mediators Association, agreed to providing our training program and training materials and documents for a course, pioneer course in Scotland. And Anne adapted the standard documents for the Scottish legal context. We said tartan versions of the standard documents. And we adapted the role play so that it'd be Scottish families, not English families. And we ran the first course in 1993. So that's how it got going. And it was the very first training group. I remember we had a meeting in the evening, and I think Anne said in her interview, they were invited to come up with an acronym, and one of them came up with this brilliant acronym, CALM, Comprehensive Accredited Lawyer Mediators.
Yeah. Do you remember who it was, just out of interest, that came up with that?
I would have to look it up. She's not a member of CALM now. I don't think she's a practicing lawyer, because I asked Anne about her. Anne might be able to remember her name. I'm sorry, but I'm afraid I can't.
Sure. Just interested in the history of it all.
Yes, I think she changed direction after that brainwave and is not a practicing lawyer, as far as I know.
That was it for her.
Yeah.
So
or not practicing family law. She's not a member of CALM anyway.
Sure, sure. So what you've described there, it sounds like a very straightforward process and there were no challenges at all. Was that the case?
Yeah, I think it was a sheer pleasure, actually, as far as I was concerned. We always had extremely nice groups of lawyers coming on the CALM courses. We ran the first courses at Crieff Hydro, which was a lovely venue, obviously. We had, yes, extremely keen, interested, cooperative groups of lawyers. And I would say there were very few challenges. I think a very rare challenge was because CALM does have a process of ongoing assessment with trainee mediators to make sure that they're comfortable with the way the training's going and that they are actually acquiring the necessary skills and so on. And so it's very rare, but if there is a trainee mediator who does seem to be having difficulty in making what is a considerable transition, I think, from the role of advising lawyer to the role of mediator. It is quite a transition to make, and there are occasionally some lawyers who have difficulty making that transition. Sometimes they just opt out and say they usually say they enjoyed the training and found it useful, but they don't want to become a mediator. It's not very common. And it's very rare that there's a lawyer who thinks they are the bee's knees, but actually haven't quite got it.
Well, thinking of that transition then, one of the main concerns that lawyers have faced in becoming lawyer mediators, it's almost an embarrassment that we lack the insight of social workers, psychologists and counsellors, and that having an adversarial breeding, if I put it that way, we're somehow becoming involved in something that we don't belong in such an important service in the lives of separating couples. So given your role in particular in bringing lawyers into this fold, what's your view on that?
I think from having had the pleasure actually of training a great many lawyers and working with many lawyers, there are a large number who have a natural aptitude, who just are natural mediators, who have a negotiating approach, who are very committed to the interests of children, not only of their own client, and who have the kind of manner and personal qualities that mediators need. And I think there are a lot like that. There are others who perhaps find it just a bit more difficult to switch from being rather more in control and giving information and seeing solutions and being a bit more directive. And those kind of lawyers can have a bit more difficulty in being non-directive and facilitative and yet not just, going around in circles. So I think personal qualities of empathy is extremely important, and obviously many family lawyers, just like mediators from other disciplines, have a great deal of empathy which they can express. I think it's one of the most important qualities because people need to feel you're really interested in them. And you need to be patient, but also able to be firm in helping to keep discussions on track and intervening when necessary. Yeah. I think you do need a sense of humour, which needs to be used obviously with care, but used carefully and sensitively, people respond extremely quickly, and it can just lighten the atmosphere. And also very much, I think, the ability to focus on children and help parents to really think as parents rather than as, warring couples.
Yeah. Well, thinking then of the nature and nurture approach then, where we've been fed as lawyers an education directed to litigating issues in separation, how confident are you, for those that are struggling a little, that a year in training in mediation can instill in lawyers the skills that they need to help couples the most in separation?
Well, there are different stages, perhaps. And I think in England and Wales, we've gone a bit further in having a single national body with delegated responsibility for setting standards for training and practice and a process of accreditation, which involves now a really demanding portfolio in which the mediator who's seeking accreditation, who has already had not only foundation training but continuing training and professional practice consultancy, which is training rather than supervision, there's a considerable amount of continuing training that goes on and practical training before preparation of this portfolio. And the portfolio has to demonstrate evidence of skills in practice, which is obviously really important. And I think no system of assessment is perfect, but I think preparing a portfolio where you have to document anonymously 3 mediations that you've done in some detail, not just giving a detailed account, but actually saying what were the challenges, what techniques or skills you used, and what with hindsight you might have done differently, or what you've learned from that. It really is a further training in itself, preparing that portfolio. And I say we, the Family Mediation Council in England and Wales, is developing that still further. And I know from experience as a professional practice consultant that it is very demanding and challenging and takes a lot of time to do this portfolio. But now, increasingly, here is going to be a requirement. You're accredited and then you're recognised for signing court forms, etc., that we have down here. And I think this is the direction that family mediation needs to go, and has gone indeed in other European countries. France also uses a portfolio system. Ireland is developing, I think, the same way. And it is necessary, I think, to be able to demonstrate how you use mediation skills in practice. Just attending a course and having a recommendation, I think, is not really enough.
Yeah. Do you see that changing in Scotland, do you think?
I hope so. I mean, it does take a lot of effort and a lot of time. Maybe CAR members won't thank me for saying that I think it needs to go further, but I think actually it does, having looked at experience in other countries as well, and research findings which show that even when you have been through a lot of training and have a lot of experience, you can still not follow all the principles and skills in quite the way that we think we might be doing. There are still weaknesses that we need to be aware of and address. And in order to provide the highest possible quality of service in what is actually a very demanding field of work, I think we really need to go on working at defining what the key skills are and demonstrating how you actually use them. Not just about them, but how you use them when you're perhaps in quite a stressful session with 2 very angry and upset people, that you still manage to use those skills in a way that seems to them balanced and empathetic, and that they can respond to. In court, I think the time may be very short, and they may be obviously competing with each other more to each prove their point of view and prove they're right, the other one's wrong. So the whole stance is different. And if there's a social work report or report on the child, it's very different context, and the feelings are completely different. Whereas if you're sitting down in a private room with both parents together, I very often ask them, if they have photos of their child on their mobiles, which most parents have these days, and actually looking at photos of the child and asking questions about the child. It's amazing how parents then look at each other, their tone of voice changes, and they become much more child-focused and talk as parents and laugh more readily than obviously would be possible in a court setting.
That's right. I'm just wondering, when you were talking there about how mediation is carried out, and I'm wondering, obviously you've been mediating since, as I say, 1978. Do you see a difference in the way mediation is carried out now as it was back then?
Yes, I think it has, or I certainly hope it has developed. I hope that it's expanded in that we've developed more models or ways of mediating. Sometimes I think it is necessary to discuss with parents, say they both have a new partner, and both new partners are really involved in looking after the children, feeding them or whatever. Sometimes both parents say they want their new partners involved because they are centrally involved. It needs to be balanced, but I've certainly done some mediations. You may then need a co-mediator, possibly, but expanding it by bringing in key third parties. Sometimes, grandparents are very involved. I'm thinking of one mediation where grandparents wanted contact with their little granddaughter, age 3, because their son had a very serious drug problem and wasn't able to have any contact with his little daughter. His parents wanted contact with their granddaughter, and to cut it short, we set up a mediation with the grandparents, the mother of the child, her new partner, and co-mediators. So 6 of us. And actually it was very productive. I'm not sure we would have done that in the early days. So I think it's thinking more in terms of family systems and children's attachments, who they are attached to or who it's recognised they need to be attached to keep attachments or form bonds. And with society becoming more increasingly multicultural, I think we need to think about mediation with families and parents from different cultures, children who may be actually biracial, and sometimes in some cultures, senior family members or senior members of the church or local community may need to be actually brought in with consent. That's, again, quite a change, but one I think that we need to be open to and to work on and develop.
Yeah.
I could probably go on, but that may be enough.
I think what you're suggesting is that it's fair to say that as we've been practicing mediation over the years, mediation effectively has developed,
Yes.
so it's more able to mould itself around the needs and wishes of the parties themselves. Is that what you're alluding to?
Yes, I think it is developing a form of mediation that you really need to design with the usually it's two key participants, that you need to think through with them what ways forward there are and how to structure the process, instead of just imposing one basic standard model on them, which doesn't suit everybody. It's more designing a model with and for them, which needs to be more flexible and more imaginative, and I think more creative, to be aware of the links with the legal process to help them understand that while it's confidential, one still needs to understand the connections between the family mediation and the court system, or with the child protection system. So it's what I call a systemic approach that helps families keep more control over their own decisions, their own arrangements, and reduces the need for authorities to step in and take control away from them, which means you need to understand what other systems are out there and how they function.
That's right. Well, thinking about the systems then, and you mentioned court there as well, in your neck of the woods, they have introduced information meetings,
Yes.
which are mandatory for parties to go to in certain situations. Do you want to talk a little about them?
Well, it's actually a requirement, unless there are exceptions, but otherwise it is a requirement for the applicant to the court. It's a requirement for the applicant, but not for the respondent. The respondent is encouraged, but not required, which we have raised questions about, because it really would work much better if both of them were required, not together. They should be seen separately. But of course, while the respondent, who may not really understand what it's about, isn't required to attend, a great many don't. They didn't really understand, probably, what information they could get from an information meeting. They just may think, oh, I don't need to take any notice of that. So quite a number maybe as many as 50%, ignore or don't respond to a letter of invitation to attend. But then, of course, you can't get anywhere if you only have one of them.
Yeah.
I find that if one meets with each of them separately to discuss not only mediation, but if appropriate, collaborative law or the court, or what steps forward are possible, I find that a huge majority say, oh, I'd rather try mediation. Yeah. Because if they understand it and have some reassurance, and their concerns or possibly fears are addressed so that risks are avoided, because one does have to be careful about risks, clearly. I think if they feel the process is suitable for them and worth trying, it's actually quite rare for people to say, oh, I understand it, but I don't want it, because they can see otherwise they may remain stuck for a very long time.
Yeah, yeah. Although I've seen some of the figures with the legal aid take-up down south recently, and there's a suggestion that perhaps, as you say, people aren't going to these information meetings, but they still seem to be getting into court, notwithstanding that. Do you know whether or not the system is working?
I don't think it's working nearly as well as it should and could work. As I don't deal with court forms and so on, I can't see, I don't know what really goes on. But it sounds as though quite a large number of applicants are somehow able to fill in the form or sign it themselves and somehow get to court. I don't know quite whether whether the exceptions about domestic abuse are exaggerated or quite what it goes on. But it seems that really quite a considerable number bypass the information meetings and don't take it up. And the courts vary. I hear of some who do actually send applicants back and say, look, you need to attend an information meeting about mediation and dispute resolution. But it seems that many courts don't. Mm. Therefore, there are still many people going to court who might use mediation but don't possibly even understand it or don't know it exists even. As I say, it can be difficult to get hold of the second participant. And a lot of people, including professionals, still don't know that legal aid is available for mediation. I talk to people and find they think, oh, legal aid's gone, hasn't it? And if you say, well, I've talked to NHS counsellors, actually there's still legal aid for mediation for those who qualify. It's completely free, and a small amount of independent legal advice alongside it to formalise, say, a consent order. I find that actually amazed. They don't realise that at all. And if professionals don't know that, certainly the general public doesn't either.
I don't know if you're aware, Relationship Scotland recently produced a manifesto, and one of the things that they're wanting to focus on is the possibility of these information meetings being introduced in Scotland. So having seen how they work or don't work down south, obviously we have an opportunity here to try and design a system that does work. Would you have in mind, if you were to scratch it and start again, how it would work better?
Well, I would say make it a requirement for both participants. A requirement for both, because I think the objection to that was that it would be against the rights of a person who wasn't intending to go to court to require them to attend an information meeting. But I think there are two answers to that. One is that there should be an equal right to information. And it is information. It's not forcing them to accept mediation. Mediation is voluntary. So I think there should be an equal right to information if either participant or party is intending to go to court. They both should have equivalent information. And secondly, and perhaps it should be for best interest of the child, where there are children involved, and there aren't always children involved, but where there are children involved, there's ample research showing that prolonged conflict litigation is harmful to children, both in the short term and possibly in the longer term. Therefore, parents who are in dispute over children, which is only in England and Wales, 10% only parents actually go to court about their children, but many more, in fact, have disputes and conflicts about children. So if there are difficulties, disagreements, or no contact taking place at all, perhaps, then I think it is perfectly justifiable to require both parents, not just one, to attend an information meeting to look at needs of all those involved, including children, and what possibilities there are, what ways forward there are, and whether a process can be designed that both key participants would be willing to at least try, because there's no commitment to a long-term process. Either can actually end it, the mediator can end it, and I find that if it should get too heated, or one or both get really upset, I find that just seeing them separately for a short time helps to calm them down enormously, and very often then they're able to come back together for a short time to focus again on, key step or key arrangement, say for the coming week. And often you can hold something like that, whereas if you just let them begin to shout at each other, one will storm out and then it's gone. So I think it's about flexibility, being able to take initiatives, and people trusting you to do that. And if you can reach them in the first place through a requirement to attend, making it clear it's not mandatory mediation, it's information, understanding what routes there are to getting things sorted out, rather than what may be a very long drawn-out process and costly process of having decisions imposed on you, actually. Yeah. I think that's really justifiable, and I would be delighted if Scotland goes that way.
Yeah, that's right. I mean, one of the issues, I suppose, has been the suggestion that these information meetings come too late, and that perhaps earlier intervention might assist. Is that your view as well, if there was information provided before?
No, because I find that people are referring themselves more now through the internet, and so they're looking up information online. They may be some way off any intention to go to court. They may be still at quite an early stage of separation, but they're looking up online what services are there, what information is available, and they begin to find out about mediation, and they refer themselves. And that may be at quite an early stage when court is only on the horizon, and they very often say, I don't want to go to court at all. So it's not that they're intending to go to court, they're hoping to avoid court, but they're taking steps to sort things out. So I would say that the parents, couples I see are mostly early stage and often self-referred, and only occasionally later referrals. I can think of one or two where there's been something like 6 years of litigation.
Wow.
And they're very difficult to help, because by this time children are teenage, sometimes late teenage, and they are just sick and tired of all this going on, and they vote with their feet. And then, yes, one has to respect them, which leads us on perhaps to listening to children, older children and teenagers, because it's their lives too. And if they can be consulted, preferably before parents have got in such a mess, so much the better.
Well, I'm glad you brought the discussion round to that. You mentioned or alluded to something called child-inclusive mediation. Do you want to describe a little bit what that is?
It's, first of all, explaining to parents that children, well, in England and Wales, children of 10 and over actually have the right to be consulted, if they wish, when arrangements are being made that concern them, that affect them. And some children really want to be involved and have a say. Their preference usually is within the family, privately. And many parents say, oh, we do talk to the children, we've discussed it with them. And there are parents who can sit down together and talk with their children, and that's really fine, obviously. Other parents who can't talk to each other and don't know what the other parent is saying or not saying to the children. And there are a lot of children who write into this website that we'll probably move on to talking about, Voices in the Middle, there are a lot of teenagers writing in to that website saying, nobody ever asked me, I never got a chance to say what I wanted, I felt left out, and reporting really very negative experiences and saying they wished they could have been involved and could have contributed. And I find when parents agree to, it's usually, I would say, a child over 10, but of course there may be younger siblings, so it could be a 12-year-old and a 9-year-old, and children vary enormously in how they mature. So I'd rather not give a rigid sort of age, but children who want to have a chance to talk and are not afraid of doing so, understand they're not going to be asked to make choices or have responsibility for decisions, but it's just a conversation about how things are going for them. Have they got any suggestions about what they think would work better? And often they have. And sometimes they're suggestions that parents simply haven't thought of because they've been too busy with many other things that parents have to deal with. And children can come up with really good ideas, or things that really concern them, like, so where's the dog going to live? For the child, where the dog is going to live may be incredibly important, but parents may not have thought to tell them that, or maybe haven't discussed it. Sure. So it's looking at things from the child's perspective instead of from an adult perspective. And I would say freeing up communication, because usually children or young people are seen separately, not with their parents, because obviously they'd be very inhibited sitting with both parents. So usually the arrangement is that they will be seen separately in different combinations, maybe siblings together and then separately, any combination that works for that family. And then if they have particular messages or a suggestion they want conveyed and shared with their parents, that might be done with them together, if that's how they want it, or it might be done with the parents afterwards without the young people being present. Again, each step needs to be planned as you go along to make it comfortable for everybody. And I would say that it's really helpful, and that families say they couldn't talk more easily after that, because often it sort of opens up channels of communication that have got blocked. So they understand each other better and can ask each other questions more easily. And children feel, well, I do count, I do matter, and I've had a chance to take part.
That's right. Although some might argue, not me, but some might argue that given how much the kids might have witnessed already in the separation and the lead up to and after it, that perhaps it might not be in their interest to be involved at all in the process of sorting out the big decisions after separation. I'm gathering that's not your view.
No, it isn't. And I don't think you'd find that it would be the view of young people. If you asked, for example, the members of the Youth Council on Voices in the Middle, they're the ones who should answer that. And I think they would say, and if you read their stories on the website, I think you'd find they're saying, we've seen this going on, where they've seen too much negative behaviour going on, they actually want to be heard more than ever in order to say, please stop it, please be civil to each other, please don't badmouth each other to us, because we hate that. They have really important messages that parents need to hear, and they can put them very strongly and very constructively, because they actually show an awful lot of empathy with what parents are going through, but they can also tell parents what they need, which is don't keep on attacking each other, arguing, fighting. It doesn't do any good. So I think they would say, no, all the more reason to bring us in, because we know what's going on, we've seen it. Yeah. Other times, there's a poem now on the Voices in the Middle website, do read it, yes, where a 16-year-old is saying, actually it was difficult because her parents never gave any sign that there were problems. So it was a huge shock. The children hadn't picked up that there were problems in the marriage, and then they were told their parents were separating, and it was a very big shock. And she's questioning whether silence and holding everything back actually is helpful too. That, you know, protecting children or thinking you're protecting children actually may not protect them if then there's some really big shock and they're not prepared for it, they need more preparation and explanation to be able to adjust. So all these insights from young people, I think adults need to listen to more carefully. And I hope we can and will.
Yeah, so thinking about then the process that would allow children to have a voice in mediation, and again, coming back to the training side of it, can you explain how confident parents can be in allowing their kids to be spoken with in terms of the training that a mediator might have?
Well, I think it helps to start with looking at what both parents and mediators may see as pros and cons. Such as one that you put forward. I think it's really useful. There are quite a lot. Actually, if you start making a list, there's a considerable list of possible disadvantages, possible risks, concerns, which parents may voice and mediators may voice, because mediators often are really quite wary of involving young people directly. And so you get quite a long list of potential disadvantages. But if you look at how it could be done and how it could be structured, actually, I think one can find ways of minimizing those disadvantages and risks. And if at the same time you look at potential benefits and what are the benefits and how can they be maximized, I think what comes out of that is often reassurance that the things that adults may fear happening actually don't seem to happen in practice if you prepare carefully. And if parents, for example, very often actually have a tendency to think that the other parent is manipulating the child, blocking contact. It's a fairly common accusation. You know, you're telling the child awful things about it, etc. In mediation, I find that parents actually very often reassure each other that is not happening. It's an understandable fear, but they're not. And sometimes where there are mutual accusations, I mean, I don't go back over who said what to whom, when, but just say, could there be an undertaking that from now on, anyway, and neither of you will run each other down to the children, that you will speak of each other with, at least with respect, and so on. And I find parents actually will sign up to that because they see the point of it. They see that it upsets children. And in relation to not briefing a child and saying, mind you say this and mind you say that, you know, if I'm discussing with parents whether they think it would be helpful for a teenager, old child to come in, I would discuss with them that if either or both parents tell them what to say, then there's really not much point in them taking part. And you can see from parents' expressions, their eyes, that they see that too. And of course, with a teenager, that may not work anyway. It may be counterproductive. So, I think if you hopefully develop skills in communicating with young people and putting them at ease, I hope one can begin to pick up feelings that are coming from them. Quite often I would say they volunteer, my mum or my dad thinks that I'm being told to say this, but I'm not. This is what I think. I think this because, and they make it clear that this is their own feeling. And then you can say to the parents, this is really coming very strongly from them. And they're saying very clearly, it's not what they've been told to say by anybody else. It's their own feeling. And this is what they're asking for and what I'm kind of understanding that they're looking for.
I'm wondering then if parties are then hearing what their children have said after there has been a consultation with the children. I'm wondering how that affects the mediator's neutrality with the parties. Let's say, for example, that one party has thought that something has been said to the children, and the children are saying, "No, that's a load of rubbish." And the mediator's coming back to say that. There has been a suggestion that perhaps in that situation it might be best for a separate mediator to undertake the consultation with the children. What's your view on that?
Again, I think going back to preparing and planning it with the parents, it's helpful to look at the different options with them. Do they think it would work better to have a different mediator coming in, or a child counsellor, or somebody different? Again, it's sort of pros and cons. I think it does depend on the parents and the family, but again, they seem to think quite often, because I always ask them, have you told your children that you're taking part in mediation? I always encourage them to tell them anyway. And well, parents tend to say, well, they know, and children know you by your first name. They sort of know you, and they know we're both meeting with you, and they find it easier to meet with you because you know both of us. And I think if you ask young people about that too, I'm not saying that this would always be their answer, but they do find it, I think, easier to talk with somebody who does actually know both their parents and who clearly must have enough trust from both the parents to be meeting with them. Whereas if it's a total stranger, well, it may be harder because they have to explain more to a stranger who doesn't know both the parents. And I think then it may be a little bit harder for them to engage, whereas if you know both their parents, you can start by saying, well, your parents have talked a lot about you, which usually gets a smile, and they say you're very keen on such and such, and you're kind of into a conversation quickly, rather than sort of trying to, break the ice.
Sure.
And what it says, I haven't found problems in giving feedback. Reassurance that children are speaking for themselves, I think can be addressed to both parents. So I don't think that causes difficulties. I think if a child has been under pressure, maybe for a long time, or is particularly upset and raw and angry and doesn't feel ready to see a parent or doesn't want to see them as often as that parent wants, then that is more sensitive, especially if they're living with the other parent. And if it's a message that will be harder for one parent to hear than the other, then I would actually ask both parents if it would be okay for me to meet with each of them separately, as I've done at the beginning. Because the parent whom the child is living with, well, if it's that way round, of course it could be the other way round, but may know very much already what the child is likely to be saying. And it's harder for the one who perhaps is less close to the child, who hasn't been seeing the child. It's more sensitive to that parent. And so I would then structure the feedback differently. And then if one parent needs to be, just to back off a little bit, not to keep pressing, because again, teenagers, if they get frequent phone calls, texts, are you coming on Saturday? It can be counterproductive. And I think you can explain more easily to a parent on their own, could you just ease off a bit? They've got exams this summer, they're feeling pressed, as I can think of just recently. That can be understood, whereas if the other parent is sitting there, not overtly crowing, but rather told you so, that's very much more difficult. So I think the whole thing needs to be very sensitive and planned step by step, rather than this is the way we do it, step by step, 1, 2, 3, 4, because that won't work for everybody.
Yeah. Well, you mentioned, just to tie things up a little, you mentioned before about voices in the middle. Do you want to talk a little about that?
Yes, I think it's such an important small charity that's driven forward by young people themselves. And there aren't many, I think, that young people are creating and managing themselves. And I think it's so impressive. There's a youth council of young people aged 14 to 22 that's expanding. We've just got the first member from Scotland, who's just graduated from Aberdeen. And she wrote in and said she'd love to be able to help. She's got very valuable expertise to offer. She's keen to help. And I hope we'll get more from Scotland because it is young people themselves. It's their experience and their voices. And they have ideas. And they've got a lot of drive and they're creative. And so they've got a meeting set up in England with the Minister of State and Ministry of Justice is going to meet with them in the autumn. So they're really taking things forward.
And what's the ultimate aim then of Voices in the Middle?
Well, I think there are several. I think the first one is to say to any young person going through parental separation and divorce, you are not alone, because an awful lot have felt very much alone. Not talking to parents because parents are preoccupied, not talking with friends because sometimes it feels too painful or too private, and feeling very much alone, very lonely, and holding an awful lot in, and perhaps staying in their own bedroom, very lonely and suffering a lot. And so the first message is to say, you're not alone. We've been through this too, and sharing feelings that may be painful but also supportive, and giving each other very sound, constructive advice. Don't let it throw you off track. Keep going. Believe in yourself. Have your own goals. It's not your fault, and so on. And it's really good to see them offering that to each other, and they're writing in increasingly to the website with their own experience and advice, and finding, I think, from my knowledge, support through each other. They can reach out to other services, and I've been helping to compile a directory of mediators south of the border who not only have training in child inclusive mediation, but actually experience of providing it, which is important. So it's possible to look online and find mediators with that additional expertise in your area or region. And so I think it's support, I think it's sharing, and being able to access more information. And in relation to government policy, there was a report last year, the Voice of the Child report, on the need for children to have a voice, but not much has actually happened. So it's young people saying, well, so what's happening? How about legal aid for it to make it possible for young people, parents who can't afford to pay extra, to provide additional legal aid so that young people can take part in mediation? That needs a government decision to provide that. And it's, as I see it, it's certainly not going to be huge public expenditure, because not all children need to be directly involved. There are a lot of parents, as I say, who are actually very cooperative, very child-focused already, and who do talk to their children.
That's right, that's right. Well, although I'm sure we could talk for hours on this, probably best that we cut this at this point. But I'm just wondering, just very briefly, on given your huge role in the development of mediation in the UK, just wondering how you see it in the coming years. Where do you think it's going to go from here, that and dispute resolution in family matters?
Well, I hope it's going to go forward. I mean, there certainly are obstacles. As we've seen in relation to getting take-up, public awareness. Actually, I still find that people can confuse it with reconciliation. Public awareness is still not that high. It's definitely higher than it used to be, definitely. But there are quite a lot of people who want to say, have you heard of this before? They say no. They need to understand what mediation is and what it isn't as well. So public awareness, actually reaching people and engaging them in mediation, which is not simple. And the idea of sitting down in the same room and talking to somebody you're just splitting up from, who really wants to do that? It's tough. It's tough. But then the alternatives are tough as well. And it's helping to reach people to think through what would be possible for them, what would work for them. But that's a really major task. And then I think, yes, training, not just short courses, which may not be really adequate, but how that links with continuing training, practical training, if possible, co-mediating with a more experienced mediator. I would say ideally from another discipline, because you learn so much by co-mediating with another mediator from another background, as we always did in FMA. And I think, although again it's very time-consuming and uphill, developing national standards and systems for accreditation, which is, again, a really tough task, but I think it needs to be grappled with, because if we're going to say mediation is a professional discipline, It's not just an add-on, you do a few days and you add it on. I think it's more than that. Yeah. So that requires considerable work internationally as well, because I am involved in an international group as well, because increasingly with mobility, parents moving countries and more international disputes involving children, we need to be able to network actually across the world, which means that we need to have common definitions and principles, and can't have completely identical standards for each country, but at least some basis for cooperative working. And that involves working different languages, which is another challenge, but really fascinating. And developing this collaboration, really, with parents and with families and with professionals, so that lawyers don't feel we're taking work away from them, which was the strong fear in the early days. And I used to tell them, actually, we're sending more people to you for legal advice than you're sending to us for mediation. So I think it's collaboration at every level. And there's plenty still to do, and new ideas and new developments all the time, which makes it always exciting.
That's right. Well, it's been an absolute privilege, Lisa, to talk to you today. So thanks very much for your time.
You too. Thank you very much, Scott.
And you've been watching AudioCam or VideoCam and listening to AudioCam for Cam Scotland.